Hello, my name is Jay Chauhan. I'm a lawyer in Richmond Hill and I practice here for more than 40 years. I also have a group called Angel Mentorship Group that is on the Facebook. Anyone who is a lawyer or paralegal or even the public, it's an open group that can join to understand the legal principles. And if you're a lawyer or paralegal, we do a number of videos on the Facebook and also on the YouTube to help the learning and education of legal issues. Some of these principles of law are Ontario-based or Canadian-based, but they apply also in other jurisdictions. I'm also a lawyer in India as well as in England. I'm a barrister in England, advocate in India as well. So I want to bring a broader perspective of the understanding of the law. And for the topic today, I just want to discuss how the law of trust evolved in England and how it is used in different ways in the different things that we do as lawyers and also in different areas of legal practice. So I think the law of trust essentially goes like this. A person holds the title, say a house, for example, or a bank account, but the real beneficial interest in that property, whether it's a house or even money, belongs to somebody else. This concept sounds very strange in the civil law of France and Germany, and we have one province in Canada, Quebec, where the law and the basis of that law is civil law, which is the same as French law, but modified in Canada to suit the jurisdiction of across the country, because Canada became a federal country and Quebec is just one province in the rest of Canada, and it's civil law jurisdiction. The rest of Canada is common law. And in the civil law in general, the trust is not recognized, but in Quebec it is. In the common law, it is a very important and integral part of the legal system. And as I explained before, the title to the property may be in the name of one person, but the real and the beneficial interest is the name of a totally different person. So if you look at the registry office and look for the title to the ownership of one person, it is not always guaranteed that it is the same person who really owns the property. So I think that in terms of the beneficial owners, there is usually a trust agreement between the trustee who shows the name on the title and a beneficiary who is the person who benefits from the ownership of that property. So from the tax law point of view, the tax department recognizes the trust, and therefore if the trustee is a so-called bare trustee, then the tax of the capital gains or even the income will be taxed in the name of the person who is either as a unit trust like a corporation, or the benefit goes to the beneficial owner of the property, and it may be taxed in the name of the beneficial owner. So it is very important to understand the trust concept, because it can involve not only a small amount of money but large amounts of money, and you're accountable not only in the tax law but in legal ownership point of view to understand and recognize the so-called beneficial owner whose name may not show up in a document but is the real owner of that property. Now, how do lawyers deal with their trust in their own practice? So as far as lawyers are concerned, in all the jurisdictions in common law, the lawyers have a trust account. And the reason for the trust account is to have the funds of the client held in the name of the lawyer, but the lawyer is responsible to the people whose funds are sitting in the trust account. So usually there are two types of accounts that a lawyer has. One is a general account and one is a trust account. And even the banks in a common law jurisdiction usually knows how the trust account works. And the trust account of the lawyer should not have any bank charges, any other expenses written in it, because the trust account is an account in which the lawyer is responsible for the last penny, if you like, to the clients whose funds he is holding. If you're doing a real estate transaction and you have a direction for funds to be put, for the money to be put on the sale of a property, which can be $500,000, $1 million, then that amount is technically belongs to the client. And you may have a direction to put the funds in your trust account, but the obligation of trust requires you to then account fully to the client for the payment of the funds minus your fees, for which you should prepare an account and then deduct that amount before you hand over the funds in the trust account to the client. So how does a trust account work? That is called trust listing. All the obligations, as I think they are called, of the lawyer to those clients are equal to the total amount of the funds sitting in the trust account, and each of the names of the persons for whom you have the funds should be identifiable in your accounting system, so that if you have 10 clients and say $10,000 and each one may have different amounts, say 1,000 each, then you must know by the penny the amount of the trust fund sitting in your trust account. So that is basically the account or the funds sitting in your trust account, but the beneficial owners of the trust are the clients. And this is very important to understand that a lot of the lawyers get into difficulty because they make the decisions on the trust account by their signature, but it is very important to recognize that you cannot make these decisions casually, and your trust obligations should be observed thoroughly. So if there's a document like an undertaking, you have to be fulfilling that obligation of trust, and there can be some difficult situations. For example, you're holding the money in trust for the client to carry out certain event on the undertaking until that event is completed, and then you can release the funds. So if you define an undertaking in a real estate transaction, you should define it extremely carefully, because you do not want as a lawyer to be a defendant trying to answer the question and be accountable to a person other than a client. So this is something how the trust law affects the lawyer. Let me give you some other examples of trust that are typically important for estate practice, and also for those persons who have an estate situation dealing with a lawyer, that they should recognize and understand the trust law as well. So let's say you have a will that you prepare. In the will, you write a clause to the effect that I will have, because you have a dependent, that I will have a certain amount of money sitting in a trust account. There used to be a statute called Dependents Relief Act, but now it's a part of the general law that requires you to recognize that in a will you should prepare a separate arrangement for those who are dependent on you. So you write that clause in the will and say, I will ask my executor and trustee to hold the sum of X number of dollars from which the income shall be given to this particular beneficiary. That arrangement is a trust arrangement in which the person that you entrust for trust monies to be held is holding the money for the beneficiary of that trust. And the obligations of trust that you impose in a will to the trustee will be spelled out in your will. So the trust account that is created by that person will be held by the trustee, and the beneficial owner will benefit based on the discretion given by you in the will to the trustee. So if the clause says that I'll give you education, maintenance, and advancement or other benefit, then that obligation within those words has to be observed by the trustee. But essentially, from the legal title and understanding point of view, the funds really held by the trustee are for the benefit of the beneficiary themselves. So that's the concept of trust in the case of a will. Now, a typical will and the role that the lawyer plays in the administration of the trust also should be understood, recognized by the lawyer. And the way it should work is that the will would say that I appoint my son, for example, as an executor, and he will carry out the obligations of the executor, and then there are other some amounts of money that he should hold for other trust arrangements. Then he should carry out the trust obligation as well. So the primary function of an executor is also the function of a trustee, but the executor's role in arranging the distribution of the funds is called the executor, or if it's a woman, executrix, and they carry out the obligation of the will and bring the funds into a trust account and then make a distribution pursuant to terms of the will. So they're also a function of a trustee, but in that role, the person is called an executor. If the funds are to be held in an account until a child reaches the age of 18 or 21, then that arrangement is also in the name of the trustee. And if it's the same an executor, then he changes his hat and changes the obligation in his name from executor to the trustee, and he has to carry out the terms of that trust obligation. So I hope that was helpful. And if you like the video, please make a comment below, and you may join. Anyone is may be authorized to join our Angel Mentorship group on the Facebook. And if you like to come to the CPD lectures, we will do some lectures on a number of topics. And in these lectures, the focus will be to try to assist the lawyers to try to launch the practice for those who are in a small practice and learn the different areas of law. It is very important for if you are launching a practice, that all the stuff that you learn in university is very often insufficient. And today, before I gave this talk, I asked somebody who is a member of our group, then if they studied trust law, and the entire degree did not contain any concept of trust. So therefore, it's very important that even if you got an entire law degree, that you keep your mind open in understanding the different concepts. And I think as far as the paralegals are concerned, they do not have enough time in the community colleges to understand these technical details of the trust and similar areas of law, but they have to practice and understand those concepts, because even in a small claims court, the trust arrangements can come into play to make a decision with it. So hope you enjoyed it, and join our group and join our seminars, and they'll be announced on the Angel Mentorship group. I hope you will come there. Thank you.